your expressions of contrition, and I appreciate them more because there are other banks who've done the same thing who have not been at all contrite and have continued to brazen it out and fight every lawsuit in every jurisdiction over using every procedural defense that's available to them. But this is not an obscure provision of the law that you really, there are a lot of laws out there. I guess we can't know all of them until, and how they might apply to our conduct. But the 6% cap on mortgage payments may be relatively new, but the stay on legal proceedings has been in law more off and on at least since the Civil War, and continuously since the First World War. And the thinking behind it is that if you're in the service of our country, if you are serving in our nation's military, you should be able to give your entire energy, your entire attention to the defense of our country and not have to worry about what may be going on in a courthouse back home, how your rights may be affected when you are not there to defend yourself. That if you have a claim against someone who is serving the country in the military, it can wait until they can come home and defend themselves. And that is not an obscure law. Now, one of the other one of the members asked the last panel if someone else had made the mortgage and Chase had bought it, and the Rouse said yes, that they had got it from an independent company and sold it to Chase. And am I correct in assuming that that is now in a securitized pool, and that there are now investors who really own it? It's now disappeared into the mortgage-backed securities, so that you don't really own it, you service it. Is that correct?
We do not own the loan. That is correct.
It is owned by a securitized pool, and you service that. Is that right?
I don't know whether it's owned by a securitized pool or whether it's just owned by another institution. But I know that we do service it.
Okay.
Yes.
And I understand also that the four biggest banks, you all, Wells, B of A, Citi, service 2/3 of mortgages in the country. Is that correct?
I believe that's correct. Yes, sir.
Okay. So this is not a small business for you.
It is not.
And I understand also that your servicing unit is a separate corporation. It is an affiliated corporation. Is that correct? It's certainly a separate unit.
I believe that it is a separate unit, yes.
So it's all they do. I mean, that's all they do is service mortgages, collect payments, calculate how much people owe, give payout to people who are selling their house or whatever, foreclose, modify. That's all they do, right?
Well, they're part of our home lending business, but yes, it's a unit of our home lending.
Okay, so there are not that many laws they have to keep up with, isn't that right? This is a big deal.
There are a lot of laws that they have to make sure that they respect and adhere to. But you are absolutely correct. This is a very big deal.
Okay, this is not something that should have escaped your notice. Who is training your people, and who is training the people who are training them, if they miss this?
We have fairly extensive training programs, which we have enhanced recently, and will continue to look at and enhance to make sure that they are, clear and simple and specific. We have compliance review those programs. We have internal auditors review those programs. And now, in the context of us looking at all of this, we're having outside counsel look at these programs also. Okay,
Mr. Harpootlian made several suggestions on how the law might change. Well, first of all, I'm not clear of the status of his litigation against the Rouse as class representatives' action against Chase. That's still in litigation, right? There's some issues still in litigation.
It is still in litigation. We have just agreed to go to mediation.
Okay, but you have contested whether there is any private right of action before the law changed. Isn't that right? That's still a position that you're taking, right? That the Rouse and others who may have had their houses foreclosed upon before the law changed a year ago, they can't do anything about it.
Congressman, I have not reviewed our papers, so I don't know the answer to that. Okay.
Mr. Harpootlian suggested that the banks might take this law more seriously and be more careful about complying if there were attorney's fees. Do you think attorney's fees would help? A provision for attorney's fees for plaintiffs.
I think that we, as a bank subject to these rules, take them very seriously, and I think our problem was.
Well, okay.
I
Your
think-
conduct suggests otherwise, but I understand you're saying now that
Well,
you're taking it seriously.
I think we did a bad job at satisfying the rules, but we understood our obligations and tried to do the right thing and to make sure that we were in full compliance. We did a terrible job.
Okay. If someone has had their rights under the SCRA violated, first of all, why should they not be compensated for that, and why should there not be a provision to pay their attorneys by the defendant if the defendant violates the law, at least with respect to what are obviously knowing violations?
We want to make sure that we compensate the people whose rights you know, we didn't enforce you know, to the fullest extent. It's not for me to say whether and how you should amend the law to provide for attorney's fees.
My time has expired, Mr. Chairman. Thank
To
you for
follow
your
up,
indulgence.
to follow up that question, Mr. Harpootlian said that basically they were doing on a contingency basis. Your answer to me would assume that if Mr. Harpootlian were billing the rolls, that would be something that you think J.P. Morgan Chase should pay. But if they're not billing them, then that would not be a responsibility. Is that a correct assumption?
Sir, I don't recall saying or suggesting that. You know, I'm not a litigator, so I can't tell you when we have to pay attorney's fees and when you don't have to.
And I understand, but the answer to Mr. Miller's question, just his last question,
Well, that's not, I mean, Mr. Chairman, I appreciate your question, but that's actually not the way attorney's fees provisions work.
Oh, I
in the law.
understand.
Okay.
I understand, but her answer led me to believe that she was concerned about making sure that the rolls were made whole, and we certainly expect that to be the case. But, you know, the attorney's fees, I think, are part of the discussion, and in making sure that, you know, if the claim is that the rolls aren't damaged because they haven't paid attorney's fees, if that's their position, I think that they're making a mistake. Any other questions?
Just one, if I may. You know, Madam Executive VP, I mean, you followed the whole, actually, tradition of corporation that, you know, the corporation is set up to avoid personal liability and accountability.